this court if you are successful.
Okay. Thank you, my lady. As you heard, my names are Hedwig, Imbosa, Omudi. I'm a judge of the High Court and currently stationed in Nakuru as the presiding judge. I joined the judiciary on 22nd of July 1985 as a district magistrate 2 professional. And that was soon after my studies at the Kenya School of Law, so which means I have been in the judiciary all along. And during my time in the judiciary, I've risen through the ranks. I was a magistrate up to the year 2011 when I was appointed judge. And during the time I was a magistrate, I served in a number of stations all over the country, save for the Coast Province, the Coast County. I also headed 5 stations as a magistrate, and that is Eldoret, Kitale, Kisumu, Kakamega, and Kericho. When I was appointed judge, I was the chief magistrate in Kericho. That is in August 2011. As a judge, I've served also in various stations, starting with Embu, Kericho, Nairobi, Makueni, and now in Nakuru. When I was in Nairobi, I served in the Anti-Corruption and Economic Crimes Division, shortly at the Civil Division, and then in the Constitutional and Human Rights Division, before I was transferred to Nakuru. So during my the period I have been in the judiciary, and before I forget, last year in July, I was celebrating my 40th year in the judiciary. And I don't take that for granted, and I thank God for that, because it's Him who has sustained me. I've served in the judiciary with a lot of commitment, integrity, and service to Wanjiku and even our own staff. I've had the experience of working in several stations. You know, the way one handles matters in Nairobi is not the way you would handle matters in Nakuru or even a station like Kitale. The challenges are quite different. So I've had that experience, and for the Anti-Corruption Division, I was the first presiding judge when that division was set up. I worked with Justice Achode, who was giving support because she was also attached to another division. During my term also, I got an award. I was awarded by LSK in 2019 for being the Judge of the Year, which I appreciated. And when we had the vetting in 2011, 2012, I was among the judges and judicial officers who are recognized by this vetting board as being an officer who was committed to their work with good temperament and good service to Wanjiku. During the time I have presided over various stations, I've learnt a lot on how to work with colleagues, how to work with staff generally, because if these staff are not appreciated and acknowledged, and yet they are the ones who do quite an amount of work for us, we would find ourselves in a lot of trouble. So those are some of the skills that I have acquired. So besides being a judge, I'm also a mother, a grandmother, and a leader in the church. Thank you.
That tells us the kind of a person you are.
Thank you.
So how would you help to reduce the backlog of cases in the Court of Appeal?
Now, in the Court of Appeal, from what I've heard, is that we have quite a number of pending applications and then the appeals. With my commitment to good service, I would liaise or link up with my colleagues at the Court of Appeal, if I make it, and we see how we could have these applications disposed of within the shortest time and concentrate on the appeals. Because if we have a huge number of applications, then it becomes very difficult now to move to the appeals themselves.
That is one strategy. Another one? Anyway, you can think about it along the way. The next set of questions will be asked by Commissioner Mwanza.
Thank you, Chief Justice. Good afternoon again, Judge.
Good afternoon, Commissioner.
Judge, I want to ask you a question based on Article 19 of the Constitution. Article 19(3) provides that the rights and fundamental freedoms in the Bill of Rights A belong to each individual and are not granted by the state. Judge, what is your understanding about that?
So it means these rights are inborn.
Yes.
We don't get them from the state.
Yes.
Yes.
We get them because we are human beings.
Because we are human beings.
Okay.
Yes.
Now, Article 19(3)(b) provides that's so that there is continuity in terms of law. So 19(3) provides that the rights and fundamental freedoms in the Bill of Rights A belong to each individual and are not granted by the state.
Yes.
And you responded to that. And B, do not exclude other rights and fundamental freedoms not in the Bill of Rights, but recognized or conferred by law except to the extent that they are not inconsistent with this chapter. Judge, which are these other rights and fundamental freedoms that are not in this Bill of Rights?
And they are not in this?
Yes, actually the Constitution says, do not exclude other rights and fundamental freedoms not in the Bill of Rights. meaning they are not part of chapter 4, but but are recognized or conferred by law, except to the extent that they are inconsistent with this chapter. So which are these rights?
Commissioner, I can't think of any other right that is not in the Constitution here.
Oh, okay.
Yes.
Perhaps, actually, I found that curious. I think those are the rights that sometimes either they are created by law, conferred by law, or come through international conventions under 2.4. Any law, including customary law, that is not inconsistent with this constitution. So if you read that. Now, I want to ask a follow-up question. So in one of the international conventions, that's the Universal Declaration of Human Rights, Article 16. So this will be one of the rights that you probably read together in terms of 19.3b. Provides that men and women of full age, without any limitation due to race, nationality, or religion, have the right to marry and to found a family. They are entitled to equal rights as to marriage, during marriage, and at its dissolution.
Yes.
You read that? Okay. Now, if you read Article... Just give me a minute. I had it here. The one on the right to family. Article 45. Article 45, Judge says that the family is the natural and fundamental unit of society and the necessary basis of social order, and shall enjoy the recognition and protection of the state. 45.2 provides that every adult has the right to marry a person of the opposite sex based on the free consent of both parties. But Judge, if you read Article 16 of the Universal Declaration of Human Rights, the language is slightly different. If you noted, it says men and women of full age, without any limitation due to race, nationality, and religion, have a right to marry and to found a family. They are entitled to equal rights as to marriage, during marriage, and at its dissolution. Now, if a question comes before you, and there are couples of the same sex, they say they want to rely on Article 16 to declare and ask for a declaration that it's permissible for a man to, enter into a partnership with a man, or a woman to enter into a partnership with a woman, based on Article 19.3. Would you declare that as a right that's availed by the law?
Okay, when we look at Article 45,
Yes.
2,
Yes.
which defines, which tells us more about marriage,
Yes.
and this one is our constitution.
Yes.
Now, Article 16,
19, sorry. 19. 16.
16, the universal one.
Oh, yes. Article 16 of the Universal Declaration of Human Rights
Yes.
reads differently. It says men and women of full age,
Yes.
without any limitation due to race, nationality, or religion, have the right to marry and to found a family, and they are entitled to equal rights as to marriage, during marriage, and at its dissolution. There is no limitation in that article
Yes.
with respect to the person that ought to be married. Is it the opposite sex or the same sex?
Yes.
So a party has come and they are asserting their right. They're saying they've come to you under 19.3 B, and you should therefore declare a union between a man and a man, or a woman and a woman, as permissible.
Okay, Article 19,
Yes.
3B
Yes.
indicates that the fundamental rights and freedoms belong to each individual and are not granted by the state. But
Yes.
our Article 45
Yes.
talks about family and marriage
Yes.
of two people of different gender, right?
Yes. Yes.
Now, when this one comes and brings up that suggestion
Yes.
that they have a right to choose.
Yes, to choose who to love and who to partner with. Yes.
I find that to be contrary to what we have in our constitution,
Yes.
and our constitution comes first.
Okay.
Yes, so I would not allow it.
Okay. All right. Thank you. That's all, Judge.
Thank you, Commissioner.
Honorable CJ and Judge Karibu. Once again, two questions from me. One on the access to justice. This is Article 48, the right to access to justice. And having been in the institution for quite a good time, what has judiciary done to enhance this right in Kenya?
Access to justice.
Yes, please.
Okay, the Judiciary Commissioner has done quite a bit. It may not be complete, but the judiciary has tried. One is enhancing the number of judges, judicial officers, and even judicial staff,
Yes.
so that they can serve Wanjiku. And then we've opened quite a number of courts where we did not have any, so that Wanjiku can easily come to court without much struggle or spending so much money in terms of fare. And we have set up in the judiciary bar benches where bar benches where we have consultation or we discuss issues that are affecting mwananchi and even us in the delivery of justice. We also, like in Nakuru, what we do, every morning we have a team of staff, about 4 or 3, talking to members of the public who come to the court for services. So they are told what they need to do, what they should not do, if they have issues, which office they should go to, and so on. And those are things that were not there.
Okay.
Yes.
Including our Honorable CJ's vision,
Yes.
the starch, isn't it? The
Yes.
blueprint.
Yes.
Okay.
Thank you.
Now, what do you think the legislature can do to enhance that right to access to justice? Parliament, what can Parliament do to enhance that right?
Okay, the challenge that has been there is about funding,
Yes.
so that despite the fact that we have structures in place, the funding that we get from government is minimal.
So what can Parliament do?
Um,
Can enhance our funding, isn't it?
Yes.
Thank you. Thank you. And lastly, on citizenship, are there instances where citizenship can be presumed in Kenya? You can presume someone to be a Kenyan.
When they were born in Kenya.
No, a presumption of citizenship. When you talk about presumption of citizenship, then you are not sure whether they were born in Kenya, but I'm asking whether the law or the constitution allows instances where one can be presumed as a Kenyan.
Commissioner,
you must have dealt with it when you dealt with the famous case. Do you remember the famous case you really dealt with? The hot one.
Which one?
We were together at the CHR. Yes, presumption of citizenship arises where a child under 8 years, whose nationalities are known and whose parents are also unknown, is found in Kenya. The law allows that person to be presumed as a Kenyan. So thank you so much, Judge, and I wish you well.
Thank you, Commissioner.
Good afternoon, Judge.
Good afternoon, Commissioner.
What is your general understanding of extradition?
Extradition occurs when another state requests, say for example, another state requests Kenya to have someone who is in Kenya taken to that country for one reason or another, and especially in terms of criminal matters.
Give me 2 reasons in criminal matters where extradition would apply. You're right that it's another country requesting.
Yes.
Extradition, it's a very important framework in international law.
Yes.
And it is supposed to help countries deal with criminals who disrespect borders to escape justice, isn't it?
Yes.
And it's so important so that we can fight transnational crime, which is now very fast, can be committed using technology even in the cyber world, and for us to keep within the rule of law. Now, in Kenya, what is the legal framework that can be invoked to facilitate extradition?
In Kenya, we have 2 statutes. Extradition, and then in brackets, I think Commonwealth, and there is extradition for foreign. The other name I forget.
We have yes, you're right. Extradition Commonwealth Countries Act,
Yes.
that binds Commonwealth countries,
Yes.
and Extradition Contiguous and Foreign Countries Act, which are non-Commonwealth countries.
Yes.
Other than those 2 legislations, which other frameworks can be applicable for extradition as a basis for extradition?
Okay, if it involves a country that has some arrangement with Kenya, the 2 countries would do that.
You're on the right track. It's only that maybe it's the terminology, where we have bilateral agreements and multilateral agreements that can also be a basis for extradition. Now, the Supreme Court recently settled the law on extradition proceedings in Kenya. Are you aware of this case? And if you are, which case is it? And what was the legal question presented before the Supreme Court for determination?
The case, is it Okemo? But I'm aware there's a decision, and the main issue before the Supreme Court was whether it is the DPP or the Attorney General who should handle such an issue when it comes over.
And what was the decision of the Supreme Court or the guidance?
Okay. The decision was that following the 2010 Constitution, the DPP's docket under Article 157 is to deal and handle criminal matters, and not as before when the Attorney General was involved. So it is the DPP who should handle that, since it's a criminal case. But the Attorney General is, the request comes through the Attorney General, who now notifies the DPP.
Taking into account that the DPP under Article 157 deals with criminal matters and the Attorney General under 156 deals with civil matters, did the Supreme Court categorize extradition?
No, extradition is mainly concerned with crimes that have been committed in the country that is making that request.
So did the Supreme Court attempt to categorize extradition, whether they are criminal proceedings or civil proceedings?
The Supreme Court indicated that extradition is about criminal matters.
Finally, Judge,
Yes.
would you give us 3 grounds or 3 tests that are applied as a basis for extradition or for refusing to extradite?
The first one, is it dualism?
I'm listening.
It's dualism where the country that is making that request, and Kenya, I'm assuming that the request is made to Kenya, and Kenya are in agreement on that operation. And then the other one,
Which operation?
on extraditing.
Do you mean dual criminality?
Sorry?
Do you mean dual criminality? Or which dualism?
Okay, my understanding is that these 2 countries, Kenya and the other country that is making the request, have some sort of
Agreed.
yes.
Another one?
And then another one, some speciality whereby the person that is the request is made for may be having some challenges, maybe health-wise,